All right.
Good afternoon.
Hey, good afternoon.
Miguel, is that you?
Yes, it's me.
Okay. Oh, can we have access to the recordings of these sessions?
Oh, yeah, that's not a problem. Just go to YouTube. Go to YouTube and type in BIFS space EDU.
Hold on, let me write that down. Can you repeat that? BIFS?
BIFS, BIFS space EDU. That's our channel, your video channel.
Mm-hmm.
Just click on our channel and click on videos. Then you'll see.
Oh, okay.
You'll see them.
Okay. I'm going to add your videos to my channel. Okay. Well, let me go get something to drink while I wait for everybody to come on then.
Yeah, no problem.
Please be safe this weekend. Between this corona and this storm coming this way.
Yeah.
Yeah. Okay, then I'll talk to you later.
All right.
Anishka, how are you? Hello, hello, hello.
Hello.
How is everybody? How are you? Okay. Anishka, there you are. How was your day? Leslie, can anybody hear me?
Yes.
Who said yes?
Aniska said yes.
Niska said yes. Okay. Just checking. Leslie, can you hear me?
Yes, but yes, I can. Yes.
Okay, great, great. I see Cohen hanging around somewhere, but I don't hear anything. Is that Cohen barking? I hope not. Let's give the whoever's going to be joining us a few more. Cohen, there you are.
Good day, good day.
Hi, how
Hi,
are you?
Cohen.
How's everyone?
We're
All
fine.
is well.
We're waiting for you. And there you are. We'll give it another 2 minutes, see if anybody else shows up, and then we'll begin. Okay, Leslie. Can you hear me? Okay. Uh-oh. Where did everybody? Okay, there you are. Can everybody hear me?
Yes.
Fantastic, fantastic. So, first of all, it's another week already. Didn't we just meet about 5 minutes ago?
I know, right?
Like, how come it's a week already again? And how come we're in our third week already? And how come
Already?
what the hell? That means next week is our last week already. Like, where's the time going and why? Wow, unbelievable. Does anybody have any interesting stories to share before we get into this boring trust administration stuff? No? Anything unusual happen? Did anybody get arrested? Nothing exciting, just COVID-19 and...
The storm would maybe coming this way.
Is it still coming this way?
I haven't checked the latest advisory.
Wow. Just what we need, another storm. What is going on? Who stole from the church? Unbelievable. Hopefully it will not be too intense. It'll just give us a little rain that we need for our water reserves and then move on, hopefully. We don't need anything heavy at this time. All right. Did everybody have a chance to go over the questions, the answers to the questions at the back?
Nope.
Is that a we or no?
Yeah, I attempted some. The unit which you have
grade 6
different
and
from us,
7.
are you able to email it to us? like with the information you have different, can you email it to us?
I'm gonna, you mean the notes itself?
Remember that was unit, when we had different reading material, I just want to have your own saved that I can read along with what we have in this booklet.
Okay, which unit was that for? I think it was one of the remuneration, huh?
I think that was unit, oh gosh.
Yeah, for remuneration, what we did last week, I think you guys had a little more of something than I did. But what I will do, I think is that one. The others seem to have been consistent. We just had the wrong, different unit numbers. So I'll send that to you for sure.
Okay.
We have two Joannes.
Yes.
Oh, okay. Same as last week.
Remember, one is audio and one is video.
Yeah, that's really cool. Okay. All right. Well, why don't we take a few moments before we get into today's discussion and go over the self-assessment questions so that you guys can see if you're on the right track. Okay, let's start with the appointment of trustees. That's the one that we backed up on. What are the general requirements to act as a trustee? Anyone? Did you find it difficult to find information in the notes, or after searching it was okay?
Only like with question 7 and 8, I was a little finding the answers for question 7 and 8.
For the appointment of trustees?
What action should a trustee take prior to the appointment as a new trustee? And what action should a trustee take after appointment as a new trustee?
Ah, okay. Well, let's go back to the top for those who may have gotten stuck or didn't get to it for some reason. What are the general requirements to act as a trustee?
Any individual who is of sound mind and
Yep.
not legally declared a bankrupt may act as a trustee.
Absolutely. Of course, you have to be of legal age as well, which is normally 18. And you must be somebody who's acting in good faith, with integrity, and using due care and attention when you're doing your trustee work. So those are the qualifications. Okay, basically 4. Number 2, what is required for a corporation to act as a trustee? Anyone?
A corporation wishing to act as, oh, sorry. Go ahead.
Okay,
A
who?
restricted or unrestricted
Like
license.
Yeah.
Central Bank of the Bahamas.
Indeed. Okay, I know what I'm going to do. I'm just going to go across and call the names. If you didn't have the answers, and I didn't get that one, or I didn't do that one, then we go to the next person until we get through all of them. That way everybody gets a
You
chance.
can just stay on initiative then.
Joanne, she's very great. I don't even see her audio and video. She said, stay on Anishka. Who answered the last question, number 2? Joanne? Okay, Anishka, you're next. What are the 3 circumstances in which a trustee may be appointed, Anishka?
Okay, 1, creation of a trust. 2, substitute for a trustee of an existing trust who has died, retired, or been removed. 3, as an additional trustee to an existing trust.
Anybody disagrees? If you do, please let us know. If you don't, just write it in if you don't have all 3 of them. All right, number 4, Cohen, what document is typically used in the appointment of a new trustee?
I put deed of appointment.
Okay, what's another word for deed of appointment?
That means adding a new trustee.
Now, be careful.
Or a trust deed, eh?
Now, who agrees
Trust
with
instrument.
deed of appointment? Is it really a deed of appointment?
Or a trust instrument.
Yeah, the trust instrument.
Yeah, I put trust instrument, so that's correct?
Yes, that's
Okay,
correct.
thanks.
We're going to get to the deed of appointment a little bit later because that has a different function. All right.
It's
Leslie.
also called the trust deed as well, right?
Yes, the trust deed.
And it's
Or
trust,
the
trust
instrument.
deed.
Okay, the trust deed or the trust instrument. Okay, Leslie, beneficiaries are required to blank and blank to be able to appoint a new trustee. There you go. So I'm looking to see if I have that one. Leslie, can you hear me? Leslie?
Sorry, I had it on mute. I
Oh,
was
there
saying
you go.
answer it, but I was trying to find the answer just now.
Oh, okay. So let's help Leslie. Joanne, help Leslie. You know, we're gonna keep going around and around.
Okay.
Don't come to me, I live
I
my
wasn't
blank.
sure that you left this blank. I was like, I don't see it in here,
I
but
left the blank as well.
I left it blank too.
I think it's probably was in a previous chapter. So I put of legal age and mental capacity.
Well, that's a good
Like
try.
sui juris, I don't know.
Yeah, sui juris. Beneficiaries are required to be sui juris.
Mhm.
What does sui juris mean again?
Of legal
Of
age and
legal
mental
age and mental
capacity.
capacity.
Sound mind.
Yeah.
Of
Yeah.
sound mind.
Sound mind.
And entitled to trust property.
Ah, okay.
Second blank. Sui juris and entitled to
To trust property.
Okay.
to be able to appoint a new trustee. So if a beneficiary is not an entitlement, does not have an entitlement to trust property, then they are not able to make such an appointment. And they must be of sound mind, sui juris. All right. Anishka again. What considerations does a court make in seeking to appoint new trustees?
Okay. In exceptional circumstances and often as a last resort, the court may appoint a new trustee as a substitute for a trustee that has died, retired, or been removed, or as an additional trustee to an existing trust, taking into consideration the wishes of the settlor and the potential trustee's impartiality and his ability to further the interests of the beneficiaries and the trust generally. Section 48 of the Trustee Act.
Thank you, Anishka.
Yeah.
You have a summary of it though? Because I was like, how do I remember all of this?
You can summarize it by saying something like the courts would consider the wishes of settlers and the potential trustees' impartiality towards the trust itself. That would be a good summary.
Okay.
However, if it comes in the form of a question, test question, then you would want to add a little more fluff to it. Or if you're answering some other part of a question and that's part of the answer, then you'd want to say quite a bit of that to give your essay question some meat. Do you follow? But in terms of trying to remember it for study purposes, that's how you can summarize it. And that's what I encourage students to do, okay? Read the whole thing so you get a general idea of what it is, but for study purposes to help you remember stuff, keep it short and to the point. And then if you need to add fluff, you can add the fluff you need to add, okay? All right, great stuff. Cohen, what action should a trustee take prior to appointment as a new trustee?
Now, I'm not sure with this answer,
That's okay.
but I put in making an appointment, the qualities to be looked for include integrity, a willing to spend time, and trouble in the trust affairs, the ability to get on with co-trustees and beneficiaries, and knowledge of financial matters, business acumen, and common sense.
Okay, anybody who agrees with that in terms of this question? What action should a trustee take prior to, in other words, before the appointment of a new trustee? What Cohen was talking about sounds like something that should be happening on an ongoing basis, not necessarily to a prior appointment. So something very specific is said about what to do before the appointment of a new trustee. Anybody has anything other than what Cohen said? They're
I
very,
didn't have anything, but I think I remembered something about him making sure he examines the trust deed.
yes. The first
Making sure there's some actual property or it's properly constituted.
yeah, the key
and
is
everything. And that he knows what he's getting into.
yeah, the key is making sure that the appointment is made in accordance with the trust deed. That's the deal. And then the second part of that answer is what Cohen said earlier, that you must make sure that what? The deed of appointment is duly executed.
Yes.
Okay, so those are your two answers to that question. Make sure the appointment is done in accordance with the trust deed and ensure that a deed of appointment is properly executed. Because if that deed of appointment is not executed, then that new appointment is not valid. Does everybody get that?
Then making sure the appointment is
The deed of appointment
uh-huh.
is executed, meaning signed and stamped if necessary.
No, the first one. I have the second one.
What is
Ensure
it?
the appointment is in accordance with the trust deed.
Yes,
In accordance with the trust deed. Thank you.
yes. And what's another name for trustee?
Trust
Trust
instrument.
instrument.
Trust instrument. Okay, great. Leslie, number 8. What action should a trustee take after the appointment of a new trustee? Now, I must admit, some of these were not
Oh,
necessary.
I'm not saying that one.
to
I'm looking at
define
them.
and dig them out, like digging conch out of a shell.
Somebody.
Okay, what action should a trustee take after the appointment as a new trustee? Anybody has anything to,
Sorry, I didn't hear you.
who said that?
Oh,
Oh, Leslie?
Leslie.
Yeah, number 8. Did you have any response for number 8, Leslie?
Sorry, my computer cut out. I was saying that, no, I was looking up number 9. I didn't look at
Number
the
8,
right-
okay. Does anybody have a response for number 8?
The answer I have is the trustee should review the trust instrument to ensure that he is aware of the specific terms of the particular trust and that he is knowledgeable about the provisions in the trust to avoid a potential breach of trust action. Additionally, he should review and inspect the trust documents accompanying the trust instrument, inclusive of the trust accounts, notices, memoranda, trust minutes, etc.
Oh, gone, I couldn't put it better myself. How did you come up with that?
What's
Did
it?
you have to dig for it or just dump it in your lap?
Now, that was
Did you have to do a little work to find that?
that's one in the paragraph.
Good, because that's what I want you to do when you answer these questions. Go into the paragraphs and dig until you find them. Some
Which
of the,
paragraph and page?
I'll let you know right now.
that answer is correct.
Page 53. 1, 2, 3, 4, 5. Like the 5th or 6th paragraph. The trustee should review the trust instrument. That's what it starts as.
Okay.
Yeah. Do you see that as well, Leslie?
Page 53.
Yeah. Page 53, paragraph what, Cohen?
Probably 5 or 6. 1, 2, 3, 4, 5, 7.
5, 6, or 7?
7.
Oh, 7. Okay. All right. Wonderful. Who's next? Back to Joanne again.
Back to me.
Oh, by the way, Leslie, you said you did number 9?
Yes.
Okay, great. What is a trust duty? And how much trust duty is required to stamp trust instruments in the Bahamas? Why don't you try that one, Leslie? What is a trust duty?
Hello?
Hi,
Can you hear me?
we can hear
Yes.
Okay. The trust duty is a fee that you will pay to validate the trust.
you. Yes. And the amount is?
$50.
Oh,
Oh, my
thank you,
bad.
Leslie. Yes, the amount is $50. Okay? So if you go down to the registrar with a trust deed, for example, that was recently or newly executed, you pay the stamp duty of $50 and that trust document is now valid. All right. Thank you, Leslie.
So what is the actual meaning for trust duty? Because that's where I still a little lost.
Leslie, what is the actual meaning again?
Sorry again? Oh, I'm sorry. I thought I had cut
The
out.
meaning of You did.
The-
He wants to hear it again.
Didn't hear you.
Okay, the trust duty is a fee that you pay to validate the trust.
You get that, Cohen?
Yes, thank you.
Yeah, that's the fee that you pay to validate the trust.
And
Okay,
the amount is $50.
amount is $50. Okay.
And
It's
then
just
I
like,
think I remember you saying you also have to add a 25-cent stamp,
40 cents stamping.
40 cents?
yeah,
Or
yeah.
25 cents?
I don't remember exactly how much. Between 25 and 40 cents to
Okay.
close the deal. Okay, so yeah, to validate the document, Cohen. It's like when you have your first child, Cohen. I'm picking on
Mhm.
Cohen today, since I don't know what he's waiting for. When you have your first child, you validate your son or your daughter by going down to the registry,
Registrar.
signing your name immediately, not like a year or 10 years later, some nonsense like that. Okay, that you are validating that you are the what?
Father.
Absolutely, of that child, unless you have some doubts, Cohen. And in the 21st century, if you have any doubt, what should you do
Get a DNA test.
in order to validate? See, validate again that you are the
Father.
absolutely. And once that DNA test says yes, Cohen, you are the bloody father, carry the seal down there and register your child. I don't care what the circumstances is, because that he or she will be your child for,
Life.
and then some. All right, fantastic. Thank you, Leslie. Number 10, Joanne again. Why is it important to inspect previous breaches of trust after the appointment of a trustee?
Because he may still be liable for those breaches. So that's on page 54, second paragraph. To ensure there is no previous breach of trust, which
Yeah.
may make him liable as the new trustee.
Absolutely, absolutely. Okay, so if you're taking on a new trust, check to see if there are any.
Even though he may have been indemnified, that may still not protect him if it's not properly worded.
Absolutely. And remember, we know from previous something somewhere that indemnities don't protect you against breaches, only against acting in good faith and something going wrong. If you deliberately in breach of the trust and it's determined that you are in breach of trust, no matter what indemnification you have, it will not protect you. It will only protect any other action you take in good faith. That's the key. Okay, so you can't thief trust property and come back and say, I'm indemnified by insurance. That is not going to work for you. Okay, all right, so that's great. Let's move on to the self-assessment for duties and powers. Anishka, number 1.
Number 1, a trustee has a duty not to place himself in a position where his duty and interest conflict.
Anybody disagrees with that? Okay, fantastic. Anishka moved. Cohen.
Okay.
Number 2.
What are the general duties of a trustee? 1, management duties.
Yes.
Example, investment, management, and distribution of trust property reasonably, fairly, prudently, and equitably. 2, administrative duties.
Yes.
Trustees must carry out the terms of the trust. 3, duties of propriety. Trustees must not act dishonestly and inappropriately, must treat all beneficiaries fairly, and communicate with beneficiaries in a professional and timely manner.
Absolutely. Okay, fantastic. All right, who's next? Leslie, back to you, number 3.
Okay, the difference between a trust and a power. On page 61, a power is where a person owns both the legal and equitable interest in property.
Yes, legal and equitable. Legal and equitable. Now be careful. Legal means the trustee owns the property that is turned over by the settlor in law. The equitable part comes in to mean that the trustee is now responsible for making sure that that property is held in trust on behalf of the beneficiaries and distributed according to the trust. That's what we mean by legal and ethical. Okay, anything more, Leslie?
I think it asks the difference between,
Okay, you told us what a power is. What is a trust?
it says, what is the difference between trust and power? So, oh,
I know that one isn't really that straightforward. Certainly not as straightforward as the definition of a power, but the real issue in terms of what is a trust is that the trustee, or it involves, the trust involves a trustee who has a legal interest in the property on behalf of beneficiaries, okay? So the trust involves the trustee who has a legal interest in property on behalf of beneficiaries. The power has both legal and equitable. That is the difference. Okay. Okay, great, Leslie. Joanne, back to you, number 4.
So number 4 is on page 60, paragraph before the last. What are considered profits for a trustee acting in administration of a trust? And profits can be director fees,
Yes.
profits made by him where he enters into competition with a business belonging to his trust, or misuse of opportunities and information.
Absolutely. Which two of the
Which he should not do. The
No.
last 2 he should not.
Yeah,
Profit.
the last two, no trustee should be involved in that crap. Okay? Anytime they move into that direction, they're getting themselves set up to be charged with being in breach of trust and eventually being removed, which interestingly enough is the source of our next discussion a little later this evening. Okay, Anishka.
Number 5,
Yes.
the Trustee Act 1998 gives the trustee power to insure himself against personal liability and pay insurance from the trust fund, except for breach of trust in the administration of trust.
Indeed. So the trustee may indemnify himself using trust funds to buy the insurance, the indemnity insurance, but that indemnity insurance will not work in the trustee's interest whenever the trustee is found to be in breach. In other words, indemnity does not condone nor satisfy wrongdoing. Everybody clear on that one?
Yes.
Very important exception in the trust world. Okay? I don't want you to think that because everybody's called a trustee that they're trustworthy. That's how we help crooked everybody else in the world of crooked trustees. Make no mistake about that, for sure. And you'd be surprised who the crooked trustees are. Sometimes they're the people or organizations that you don't expect. For example, if you're going to die of cancer soon, you may call your bishop and say, Bishop, I'd like you to be the trustee for my children, thinking that he is trustworthy. Chances are he is, but occasionally, not all of them are. The problem is we don't always know who is and who. We just make our best estimate. Okay, so it's a very, very interesting thing when it comes to choosing trustees. It usually should be somebody or some organization that we have confidence in and that we trust to a significant extent. Okay? Question for Joanne. Joanne, let me be the devil's advocate. If you were married to Cohen, would you leave him as trustee of your assets in the event that you die as your husband?
Absolutely. Yeah, I don't know if he can't be a beneficiary. Can he also be a beneficiary? No, right?
Can you be a trustee and a beneficiary? Based on your study so far? Yes, you can.
You can?
Yeah,
Okay, yes, I would leave him.
Trust law, you can.
Okay.
Absolutely. And if for some reason it is determined that you can't be both, and I'm sure you can, then yeah, if you can't be a trustee, you'll probably be a beneficiary. So yeah, so you'll say to your trustee, okay, when I'm gone, this $500,000 that I have, only give a couple dollars in your discretion to Cohen because whatever. And then make sure my children live the right life of Sir Ali. If he can't find his own way, he's somebody else's child. Is that how we should do it? Remember, I'm being the devil's advocate now.
Hold on, you're saying Cohen is the trustee and he's also a beneficiary?
No, he's
That's
not.
what I'm saying there?
He's only a beneficiary. So it's Cohen and your 3 children, they're the beneficiaries. And you tell the trustees in your discretion, make sure that Cohen gets a minimum amount and the rest go to my children. Would that be a typical set of instructions from a settler who's a wife?
No, that wouldn't be typical unless there was an issue.
Unless there's an issue. Yeah, Cohen?
Yep.
I'm not going to ask her what that issue is. What I'm gonna say to you is a word to the wise is?
For sure.
Yeah, because women are wired a little differently when it comes to allocating resources. Men, we're a little different. So leave all to my wife and she won't give any to children because we know that she's going to look after them. So we have this general thing. We said, my wife, that's it. And she has to do something like really terrible. But our wives are not necessarily like that. They are going to do it depending on.
Divide it up.
Yeah.
Divide it all up.
Yeah. And you have to, by the time, at the day of her death, you have chance to determine that you've been a good boy until then, or else. Dog eat your. Just a little stuff that's not, that's not in the text. Okay. Which question are we on?
6.
Number 6. Who's the last person? Anishka? Cohen. Leslie, number 6.
A trustee is required to exercise his discretion honestly, fairly, and in good faith.
Okay, yeah, honestly, fairly, and in good faith. If there are no objections, we'll move on to 7. Leslie?
Trustee minutes. A trustee, what are used to document a trustee's deliberations regarding his decision to distribute to a beneficiary? So the act would be found in the trustee minutes.
Yes, in the trustee minutes. Thank you very much. Way to go. All the decisions and deliberations of a discretionary trust should be recorded in the trustee minutes. Remember, trustee minutes are not made available to beneficiaries for obvious reasons. If the beneficiaries find a decision was made that they don't agree with, then you can expect as a trustee to be sued because you're always going to piss off somebody they're not going to agree with all of your deliberations. And that's why the courts do not allow beneficiaries to see the minutes of the deliberations of the trustee or trustees. Question. Can you have more than one trustee administering a single trust?
Yes.
Yes, you can. Okay. And sometimes settlers establish 2 or 3 trustees depending on how much money is involved, or they might want to have one trustee administer a certain set of assets, another trustee, another set of assets, and so on. It just depends on the wishes and desires of the settlor. Okay. Joanne, we're back to you. Number 8.
A trustee power or discretion must be a positive mental act and not an omission on the part of the trustee. And that's on page 63.
Yeah, positive mental act. No oops. Okay? You must be operating of sound mind each time. And if you start feeling like you're losing your mind, then we go to what we discussed today. Removal and or retirement, see? From the trust. All right. Who was on? Who answered the last? Joanne?
Yeah.
Okay, number 9, Anishka.
Number 9, a trustee act fairly and independently must not be seen as a nominee or a puppet on a string for a settler.
Absolutely. Okay. So if a settler settles a trust and they're telling the trustee what to do every week, that's a problem. That's not how it's supposed to happen in practice. Even though modern trust law allows for the settlor to be a beneficiary and even a protector of a particular trust, what that does, it gives the settlor too much what? Power. And of course, instead of the trustee running the trust, the settlor is essentially, in practice, running the trust. And that's always a no-no. Even if a settlor is influencing a trust for some reason, it must never give the appearance that he or she is running the trust, which unfortunately is happening in some cases in modern trust law today. But 20 years ago and before, you certainly would not see that happening with regards to a trust. Okay, Cohen, number 10, which I didn't answer, but I'm sure somebody will give me the answer.
If a trustee acts solely on the instructions of the settlor without acting independently, the trust may be at risk of being attacked as being a sham.
Any objections?
No.
No. As a matter of fact, that was exactly what I was talking about a moment ago. If the settlor is deemed to be too involved, a nominee, puppeting the trust and so on, sooner or later when the beneficiary discovers what is happening or otherwise, that matter will be taken to the courts or otherwise, and that trust will eventually, no doubt, be deemed to be a sham trust. Okay? And of course, a sham trust is a trust that is null and void.
Yep.
The trust will shut it down and declare it non-existent. All right, Leslie, trustee remuneration, number 1.
Oh, hold on, let me turn to that page.
Mhm.
A question, if a person is the trustee and a beneficiary, can that be seen as a sham trust?
In modern trust law, no, but in general trust administration, yes. And a lot of it has to do with what is actually happening from day to day with regards to the trust itself. Okay, if somebody is deemed to be a co-trustee and a beneficiary and they keep a hands-off approach sufficiently, then perhaps they can get by with not being declared a sham. But if they get too involved and keep their hands in it and keeps getting involved in decision making and changing the course of things and changing decisions, influencing the other trustees or trustee, then yeah, that trust could be in danger of being declared a sham, especially if a particular beneficiary or beneficiaries get wind of it and make a petition to the courts. They might find enough evidence to suggest that yes, this is sham behavior. Okay.
Okay,
All right, number 1, remuneration.
okay, a trust instrument may contain a clause which allows a trustee to retire.
What are you reading?
We're supposed to be in trusted remuneration.
Unit 8, that's page 68.
Oh, sorry, I
Yeah,
went ahead.
number 1.
Okay, sorry, I went ahead.
Mm-hmm.
Page 68. Okay.
Unit 8, trustee remuneration, page 68.
Okay, my book is different again. Okay. Unit 7 is for me.
It's 7 for me too. How about that? That's interesting.
Oh,
Yes. So even one of your colleagues is guilty of having my book.
I think we have the old book. They must have the new one.
I wonder how that happened, Leslie.
Hmm.
Should we protest?
I think we should. Okay, the trustee's allowed to.
Yeah, a trustee is allowed to. That's it.
Okay. Let me look it up. I'm gonna say I'm guessing now. I'm gonna
That's
say
fine.
if the trust instrument expressly allows it.
Yes, that's good.
If I told you that you're correct, what would you say? Like, what made you guess that one?
That seems to be the most logical answer.
Yeah, absolutely. And that's what I tell students when you're writing exams. If you come across a question that like, man, this doesn't feel right, I don't remember stuff or whatever, instead of leaving it blank, put some crap, see, put the field thing in like Leslie, put something in. You never know. You might get lucky. Okay?
Yeah.
So you're absolutely right. The trust instrument, unless the trust instrument expressly allows it. Okay? And we know by now, as budding trust people, that the expressly means in writing, correct?
Right.
All right, Joanne, back to you. Number 2.
Number 2, in exercising its jurisdiction, what information will a court consider? And that's found at the bottom of 66 to 67.
Which in essence says?
Which in essence says they will consider the fact that, of course, he's supposed to be doing this free, but they will also look at how well he's administering the trust, what his experience is, what other people are being paid, and any other circumstances that may be relevant.
Thank you very much. Absolutely. Absolutely correct. Okay, Nishka, number 3.
Number 3, the court's jurisdiction may be exercised to allow a trustee to be compensated for past or future services to the trust.
Absolutely. So again, if the instrument does not indicate remuneration and the trustee decides, you know what, this thing is getting bigger than I thought it would be, it's working me too hard for no money, I'm taking the matter to court and ask the court to not only compensate me for the future work that I will do, but also for the work that I've done already, and to provide them with persuasive evidence and information to support the claim. Of course, any prudent trustee before going to court would probably do what? Before you go to court, who might you consult before going to court if you're a prudent trustee?
A lawyer.
Yeah, but before the lawyer. How about the beneficiary? Yeah, remember, the beneficiaries are always a trustee's biggest problem. As long as beneficiaries are happy, then everybody's happy. If beneficiaries are not happy, then nobody in the trust is happy. So if a trustee is looking to get paid, the first place he or she might want to go is to the beneficiaries and say, look, I know I started this off 5 years ago free. It was a small trust then, it has grown. The responsibilities are huge, the risks are out there. It's a big problem now. I think I should be compensated by X amount of months of the year. And then let the beneficiaries decide. Now we know from our own reading experience so far that in order for the beneficiaries to agree, what percentage of beneficiaries need to agree?
All of them.
All of them. If one does not agree, then the matter will not go through. Okay? So he would have to somehow persuade all of them. If that doesn't work, let's say they all say, hell no, go to hell. Are you kidding me? You didn't sign up for money. Why you want it now? You bastard or whatever. And so on, just go keep working free. Then, of course, the trustee, in his wisdom, will perhaps should seek the judgment of the court in that matter. Rest assured, beneficiaries are very finicky. The courts might rule in favor of the trustee, but you might end up doing what? Losing the trust, right? Because then you might annoy the beneficiary, say, we told you no, and you went behind our back to the courts to get paid. But if they remove you, are you better off or worse off anyway? You're not worse off because you're not being paid in the first place. If you go to the courts and they say, pay the trustee and the beneficiary get mad and change you, then fine. Thinking trust. I didn't get paid anyway. Unless, of course, as trustee, you're getting somewhat unknown benefit. How about that?
Secret profit.
Yeah, secret stuff somewhere. So you're like, okay, fine. You don't want to give me the money. I'll just increase my secret profits. Cheap beneficiaries or whatever. Okay? So the point is, outside of the textbooks, some real life issues do occur. Okay? All right, who's next? Cohen? Cohen.
Can I ask a question, please?
Sorry?
I wanted to ask a question.
Sure, go ahead.
all beneficiaries are equal. There's no beneficiary that's greater than the next.
When you
Suppose
say
trust
greater, you
instrument-
mean?
Yeah, suppose in the trust instrument, I leave you as probably being the decision maker. when
You
it
mean the beneficiary or the
Trust.
trustee?
No, I leave let's say I leave my number one son, or my oldest son, the head of all the beneficiaries. Can
Oh,
anything?
like that.
Yeah.
I see what you mean. No, trusts, you could leave that in your letter of wishes as a settlor to give some indication to the trustee that that's how you want things to go. You follow?
Mhm.
And so if it's a discretionary trust, for example, then the trustee can then convey that to all the beneficiaries and say, look, it was your mom's wish that Thomas be the decision maker with regards to how things should function in terms of what happens to us as beneficiaries. Now, you're not going to normally see that like that, but it is possible to set it up that way if you're a settlor. Do you follow?
Yeah.
That's what makes a trust so flexible. You could do that, even though you don't see it like that too often. What would happen is, usually the decision maker is the trustee, and the trustee will look at your letter of wishes and say, okay, let me see what Leslie generally wants to happen with regards to her beneficiaries. And if it's a discretionary trust, then he has the right to do what you say or not. If it's a non-discretionary trust and the instrument says, do this, this, and this, then the trustee will have to do what you say. In other words, if you say, I would like my oldest son to get 50,000, the second child to get 30,000, the third child to get 10,000 every year. If it's a non-discretionary trust, that's how it must go. However, if it's a discretionary trust, even though you may have that in your letter of wishes, the trustee does not have to follow it. Does that make sense?
Yeah.
Yeah.
Okay.
Okay. But you wouldn't normally see a petition to have a quote unquote decision maker in the group, so to speak. Because typically when a trust is set up, the trustee is the decision maker based on the information in the trust instrument as to whether it's discretionary or non-discretionary.
Even when it comes to minors,
Sorry?
like minor trust.
Minors?
Yeah.
Well, if you have a minor, you could leave instructions on what you want to happen with your minor specifically, or you can leave it in the discretion of the trustee.
Okay.
Absolutely. Okay. So if you have, let's say you have a disabled child, you might want to say, I want my disabled child to get the best possible education until they are an adult and can find gainful employment on their own, something like that. And so if you specifically put that in the trust instrument, the trustee must follow that to the T. Otherwise, if it's not in the trust instrument and you say to the trustee, in your discretion, make sure that my disabled child is looked after well and proper until they find gainful employment, then the trustee in his duty of care, see, that fiduciary duty, will have the responsibility to follow your wishes. Okay, so it's a very tricky but flexible and productive document, the trust setup. That's why when you set it up initially, you have to be clear on what you want. If you want it to be non-discretionary, like you want to leave very clear instructions, put it in the instrument. Because if you don't put it in the instrument, then the trustee may have the ability to go ahead and act as he wishes, which may or may not always be good for one or more beneficiaries. It should always be in the best interest of all beneficiaries, but human nature being what it is. Okay. That's why when you leave a discretionary trust with somebody, professional trustee or individual, you have to be sure and comfortable that that person is going to look after the best interests of your beneficiaries. If you don't feel completely comfortable with that arrangement, do not arrange a discretionary trust. Set up the terms specifically in the trust instrument so that there can be no deviation. Okay? That's ideally how it should go. All right. Did that answer help, Leslie?
Yes, yes, it
Okay.
did.
Great. Next question, number 4. Who is next?
Me.
Yeah, Cohen, number 4.
A trustee may enter into agreements with beneficiaries who are sui juris and absolutely entitled to be remunerated from the trust fund.
Absolutely. If there are no objections, that is absolutely correct. And again, they must be sui juris and they must be absolutely entitled. They're not absolutely entitled, they're not beneficiaries in the context that we understand it. All right, Joanne, you again, number 5.
Okay, what is the general principle regarding, what is the general principle regarding trustee remuneration relating to assets situated abroad?
Yes.
That's on page 67.
Mm-hmm.
It says if you're, I think it says if you're remunerated, you don't have to give an account in the local jurisdiction.
Well,
Let me read it. Hold on.
yeah, that's getting warm. But what creates that scenario? What background information creates that scenario? If the assets are outside of the jurisdiction where the trust is located, let's say the trust is established in the Bahamas, it's a Bahamas trust, but the assets of the trust are in Timbuktu. Or let's say the UK, for example. Okay, what is the scenario there?
So the law of the country there allows them to receive remuneration, but they're under Bahamian or UK law. They're not bound to account for it unless they went out of their way to obtain it.
Indeed. So if it's a Bahamas trust, the assets are in the UK, and the UK allows remuneration, and the money is sitting there or somewhere, and the Bahamas trustee does not openly go after it. See, so it's a little kind of trick situation. Openly go after it, then there's no need to account for that particular remuneration. How about that? I wonder who came up with that loophole.
Yeah, what does that mean? So they could open an account over there and just automatically put it there, some agreement, but now if he send them an invoice or something, or
yeah, another kind of, absolutely. So, oh, you were remunerated for the Bahamas trust, and the trust instrument does not allow for that. See, so yeah, in those cases, you can find yourself fighting with beneficiaries. But if there's remuneration outside of the Bahamas jurisdiction in the UK, and you don't actively go after it, but it's there and it's available, as long as it doesn't come to the attention of the beneficiaries outside of the Bahamas, then that remuneration does not have to be, like, you don't have to decline it or turn it down. You can accept it. All right, welcome to the gray area. The point is, if folks are not being remunerated for their work in different circumstances, they can find ways to get it done. Okay? But we know typically that would be an exception. All right. Anishka, number 6.
7? Wait, 6? Oh, sorry. Under the rule in Keefe versus Sanford, a trustee is not permitted to allow his interests and his duties to conflict.
True or false?
True.
Absolutely. Duties and interests are not to come together. They are to be separated on a parallel line. Do not get your personal affairs as a trustee mixed up with your duties and powers as a trustee. Some trustees do that very well. Some do not do a great job, and some deliberately try to circumvent the requirement, as usual. The good, the bad, and the ugly every single time. All right, number 7, Cohen.
A trustee is also not allowed to take any profits from his position as trustee if not allowed by the trust instrument, beneficiaries who are sui juris, or the court.
Okay, so if the instrument, the beneficiaries, or the courts do not allow for profits, don't take them. If you think you're entitled to them as a trustee, go to one of those three places. It's as simple as that. But of course, some trustees don't want to go to any of those three places. They want to take it surreptitiously, quietly, sneaky, so that none of those three groups know. But sooner or later, things happen to come out eventually for some reason. And then there's a big stink and so on, okay? Which leads to our next discussion, the removal of the trustee. But it's always better to try and do it the correct way. Okay? Nothing wrong wanting more profits or profits at all. Just follow the correct route and see if you can get it done. You have three options, try them. You might get lucky at one of the three. It's always better to do that than to take the other route. All right, Leslie, number 8.
Okay, I was looking for that answer, but I don't see
I
it.
know it didn't really jump out at you, not that answer. I agree with you.
Yeah, that took me a while to find.
Yeah,
me too.
that one stank.
Yeah.
Did anybody find it?
Yeah, page 66, paragraph 3. Was that
What is the answer?
an express charging
Charging
clause?
clause.
Yes, an express charging clause, absolutely. In the trust instrument will be allowed, even though it may enable a trustee to gain from his fiduciary position, and even though it may produce a conflict of duty and interest. Doesn't matter in that case, because what?
Yes, an express charging clause.
It's in the
The
instrument.
trust instrument, yes.
Yeah. So that trust instrument is like a marriage certificate, Cohen.
So,
Once you sign that crap, you can't holler, but that wasn't me. I ain't being no church that day and all that stuff. That's you.
So normally, once a trust deed or trust instrument is executed, that's it. That can't be altered.
Yes, it can.
It can be? Okay.
Excellent question, Joanne. A lot of people believe that trust instruments that are originally executed cannot be changed. In some cases, it can be amended, not the original document, but you can add the provisions and subsequent clauses by an amended trust instrument, provided again that you either get the settlers, okay, if the settler is still alive. If the settler is not alive, then you have to go to whom? The beneficiaries, and see if you can get them all to agree to change something or add something. And if that doesn't work with the beneficiaries, they're like, hell no, don't touch that. I don't trust you, anybody. Then you can, if you think as a trustee it's serious enough, then you can petition the courts for such an amendment or adjustment. And the courts will look at your arguments and see whether it makes sense. Where? In the interest of the beneficiaries. Absolutely. Okay. But it is doable. Okay, for sure. All right. Who's next? Joanne, we're back to you already. Number 9.
No, I just went.
Sorry?
That was just me.
Oh, Anishka.
Leslie wants to go.
Oh, Leslie. Sorry, Leslie. Number 9.
A trustee cannot purchase trust property for himself.
True or false?
True.
Definitely. No trustee should be involved in no transactions. Sometimes even if the beneficiaries agree and something happens, it gets the attention of the courts and all that stuff, the transaction could still be declared what? Null and void. Okay, so we have to be careful because that's a major what? Conflict of interest. By all means. All right. Joanne, the last question, number 10.
Any purchase of trust property by a trustee at the instance of a beneficiary will be voidable, no matter how fair, open, or honest the transaction may have been.
I rest my case. Okay? So even if the beneficiary or beneficiaries agree, the transaction could and probably will be declared voidable because of its conflict of interest nature. So trustees have to be very careful. That's why we call them trustees. Okay? like in God we trust kind of thing.
Hmm.
All right, so that's a great job. Hopefully that does something to get some of those concepts to stick in your mind. That's the whole idea of doing the self-assessment, to force you back into the notes to find the responses, and whether you like it or not, some of that will stick in your mind longer than you wanted to. And that's the idea. Okay, so let's get into our discussion for the day with regards to the removal and what?
Retirement and removal of
Trustee. As usual, I have an interesting little video I'd like for you to see before we begin our discussion. And then I believe I have maybe something for the end of our discussion to kind of close us out for the day. But let's have a look at this one first. Let's see. Okay. Share screen. Man, I'm getting pretty good at this crazy stuff. Can you guys see that?
Trustee
Yeah.
removal?
Yeah, trustee removal. Can everybody see that?
Yes.
Yes.
Wonderful. Okay, here we go.
Hi, I'm Keith Davidson at Albertson and Davidson. Today, I want to talk to you about trust.
Now, the reason why I selected this one, among the other reasons, is Keith is an attorney. And so trust instruments usually begin in the lawyer's office. Most trustees do not prepare trust instruments. Let me be clear on that. That doesn't mean that certain trustees do not have a legal team within the trust corporation or company that can prepare trust instruments, but usually trust instruments are prepared by the company's external lawyer, okay? For obvious reasons. The external lawyer of the firm is independent. It's not something inside the firm, so there's less of a chance of manipulation and some other crazy stuff that people do when things are done like in-house, okay? So Keith is a practicing trust lawyer, obviously, so he sees this crap all the time, more so than any of us. And so hopefully he can give us some insight.
Removal. And it's important to understand how you have to go about trying to remove a trustee. It's no easy task. But let's say you've come into my office and you've asked me, how do I go about removing a trustee? I have a trustee of my trust, and for whatever reason, they're not managing it properly. So maybe they're not investing right, maybe they're not making distributions to the beneficiaries when they should, maybe they're spending trust assets on themselves. It's any number.
And bear in mind that what he's referring to is probably a beneficiary or group of beneficiaries who are disgruntled. Remember that discussion? And so now they're going into the lawyer's office, their lawyer's office, and saying, look, we are the beneficiaries of this trust, and for X, Y, and Z reasons, we would like to have this trustee removed. You can see right away, he has a disclaimer right from the beginning. Removing a trustee is not necessarily an easy task. It's not as simple as get the hell out, okay, as we shall see.
Things. And so the question is, how do we go about removing the trustee? And basically, in order to remove a trustee in most instances, you're going to have to go to court and seek the court's help. Now, there are times when a trust document will give somebody the power to remove a trustee, and that's an important little footnote here. So the first thing you want to do is look at your trust, because if it gives the beneficiary or somebody else the power to change the trustee or remove and replace, then you're going to want to exercise that. That obviously is the very easy way to go. But most trusts do not have that power. And so most of the time, the beneficiaries are stuck having to appeal, go to the court. And that means filing a petition to remove the trustee. And there's two things you can ask the court for. You can ask that the trustee be removed, but a removal petition does take a trial. So that, unless you reach a settlement, you do have to take that issue all the way to trial. While that matter is pending in court, and it will take some time, you can also ask the court to suspend the trustee. So it's just an interim temporary suspension. The trustee would be removed, just for a temporary period of time until the removal is determined. And some other party would be appointed. Usually it's a neutral third party, like a corporate trustee or a private trustee, a professional, but somebody would be appointed to oversee the trust during that time period. The bases for removal, there actually are quite a few of them if you look in the probate code, and it can be as simple as a trustee failing to account. It can be a trustee breaching their duties. It can be a trustee creating hostility.
Okay, so these are all the different reasons why beneficiaries might want to remove a trustee. They're trying to get accounting information. The trustee keeps saying tomorrow, tomorrow, tomorrow. They produce information, bank statements, financials, or whatever that don't add up. And so the beneficiaries are now becoming suspicious of the trustee's behavior. So it can be any number of reasons, usually primarily led by money issues, but money issues are not the only ones.
There's quite a few bases, but what you find if you do this for a while, like we have, is that a lot of judges will not pull the trigger and actually remove a trustee unless they really feel compelled to do that. And so it might be true that under the probate code, the court has the discretion to remove a trustee if they didn't account. Most of the time, courts are not going to do that. Just a simple lack of accounting is not going to get a trustee removed, because the court can just order them to account, and then at that point, the trustee accounts. So really what you need is one of two things. You either need something that's really bad, and by really bad, I mean a trustee stealing money, and you have proof of it. So they're just taking money right out the door into their own pocket. Or you have to have what we call death by 1,000 lashes. So that's where you kind of stack up all the things that they've done. There may not be any one thing that's huge. They haven't actually taken money. They're not embezzling or anything like that. But if you just stack up all the things that they've done, they've breached here, they haven't invested right, they haven't made distributions, they're creating hostility, and you layer those together. And once you have enough of them, then you may be successful in persuading a judge that this trustee should be removed. But it's not an easy course to take. Unfortunately, in some situations, you have no choice. You have to try and get a trustee removed, especially if it's a bad trustee. But you should know going into it that you are facing an uphill battle. And so you have to line up the evidence and the facts properly if you're going to be successful in trying to get rid of that bad trustee.
Very interesting. So in case you thought that getting rid of a trustee was a simple matter, welcome to the fact that it's not a simple matter, and that any beneficiaries or others who think that they can just say, we're tired of this trustee, or they're getting on our nerve, we want to get rid of them, they don't do everything we say and all that kind of stuff, get them out. It's not that simple, especially if the trustee is not willing to go. If you have a willing trustee who's ready to go, say, man, I was hoping you guys would do this. I wanted to go 5 years ago. Then that makes the job a little bit easier. But if you have an unwilling trustee, you have a big problem on your hand if you are a beneficiary or beneficiaries. Okay. And so as you can see, even going to the court, because once you hit even the courts are reluctant, because finding a new trustee, getting somebody acclimatized, like getting married again.
Mm-hmm.
Anybody in the group ever been married again?
Never been married.
Oh, okay. So you guys are just a bunch of babes in swaddling clothes. You don't know what the hell's going on. I encourage you to just, keep studying and learning stuff until the time comes to get married and have kiddies. It's going to be a whole different time in your life. I'm sorry, I'm laughing at you guys because you haven't even gotten started yet. I hope.
Anishka and Cohen.
Cohen? Cohen, can you take a hint yet? They say that guys are dull as hell. We can't take a hint if we hit somebody hits us with it. But yeah. So yeah, getting rid of trustees is not easy. Even when you go to court, it's like trying to go to court to get a divorce. Notice courts generally make it what? Difficult to get divorces, correct?
Quick to get into and hard to get out.
Absolutely. it seems like it should be the other way around.
Yeah,
It should be made hard. Like,
jump over hoops.
yeah, you have to be together first for 3 years. Then you have to go to marriage school to get
So
a diploma.
yeah,
Yeah, two. So by the time you get married, like you've already been together 5 years, and then you can decide, do we want to get married still? And maybe if we do that, some marriages might last a little bit longer. Okay? But we make it so easy, like everybody just go, like how fun. Let's go party, go to the movies, have wine. Let's get married. She looks sweet now. Mother's sick. He's a hunk, like whatever. And let's get married. And then,
what was it?
my. So getting rid of a trustee is like that. When you go to court to say, we want to get rid of this trustee, the courts will try to discourage beneficiaries and say, guys, what's the problem? We don't think he is not accounted in 3 years for the trustee funds. Instead of the court saying, okay, fine, that's good enough reason, get the hell out, Mr. Trustee, you'll get a new trustee. They'll tell you, look, beneficiaries, we'll simply instruct the trustee to give you an accounting for the last 3 years. And if you're satisfied with that, we move on. Because courts are not anxious to change trustees unless they feel compelled. You have to give the courts a compelling reason. Okay? So this thing about removal of trustees, it's like getting a divorce sometimes. It could be very difficult and frustrating for the parties concerned. All right. Can you guys see the notes?
Yes.
Yes.
Beautiful. So we're going to start with Cohen then tonight, since he's on the top of my list. Okay. Let's start with retirement.
Retirement. Retirement of a trustee. A trustee may retire by an express clause in the trust instrument under Section 47(2) of the Trustee Act by the beneficiaries, suitors, or by the court. A trustee may retire without a replacement if there are at least 2 trustees or a trust corporation. He may also retire where the existing trustees consent to his retirement, or the trustees may execute a deed of retirement. Where the requisite consent cannot be obtained, the court has the inherent power to discharge the trustee without a replacement.
Okay, now notice he just read 2 short paragraphs, but these are loaded paragraphs. For example, first of all, any kind of retirement of a trustee should ideally be done by an express clause where? In the trustee. It should be in writing. So anybody establishing a trust for the first time ought to give consideration to the issue of retirement, which is why we hear the expression, get a good lawyer when you want to have, if you're a trustee, get a good lawyer to draw up the trust instrument. If you're a settlor and you're getting your own lawyer, find a good lawyer to come up with the trust instrument, because it is important that these important clauses are not omitted from the trust instrument. Okay? Because oftentimes if they are omitted or they're drawn incorrectly or inconclusively for some reason, create a problem down the line when the time comes to deal with retirements and removals. Okay? So the first thing you want is a trust deed that is clear on how the retirement process should work, period. If for some reason there's no expression in the deed, then we in the Bahamas and the modern trust law can then go to our Trustee Act. Did anybody attempt to find that section of the Trustee Act? Who has the Trustee Act? Somebody pull it up. Section 42, subsection 2.
Section 47.
47, subsection 2.
Okay.
Yeah, read that section for us.
Okay.
That's what I'm talking about. Yeah, she's still searching it out, picking it up, finding that section. That's what I want you to do. It adds to the dynamics of your learning and also encourages you, like, wait a minute, to be inquisitive. So really? Let me have a look at that bloody thing. God forbid. Students,
Okay, section 47(2). Whereby a deed, a retiring trustee is discharged under the statutory power without a new trustee being appointed, then A, if the deed contains such a declaration as aforesaid by the retiring and continuing trustees and by the other person, if any, empowered to appoint trustees, the deed shall, without any conveyance or assignment, operate to vest in the continuing trustees alone as joint tenants and for the purpose of the trust, the estate, interest, or right to which the declaration relates. B, if the deed is made after the commencement of the act and does not contain such a declaration, the deed shall, subject to any express provision to the contrary therein contained, operate as if it had contained such a declaration by such persons as aforesaid, extending to all the estates, interests, and rights with respect to which a declaration could have been made.
doggone it. Usual legal mumbo jumbo. But again, it spells out clearly what the conditions are in terms of establishing the retirement of a trustee in relation to any other trustees that are co-trustees or other. In this case, other refers to persons like protectors and beneficiaries who might somehow be a part of that process, which is why it is important to have quote unquote experienced lawyers, for example, or persons, if they're not lawyers, who draw up these trust deeds so that they can go back to the various acts and clauses to make sure that the instrument is indicating clearly what the conditions are. Okay? Very important. And then, of course, failing the instrument and the act, we always have the courts to go to rule on our behalf. That really is the key. Now, notice in the second paragraph where it says at least two, if there are at least two trustees or a trust corporation. Now, did we have any discussion at all about a trust corporation? Or are you hearing that for the very first time in your life today?
You mean with the corporation being the trustee?
Of course.
Yes, we did.
Yes, we did have that discussion. So
Yes.
if there are at least two trustees or a trust corporation, a trustee may retire without a replacement. So again, if you're a single trustee, then you need to find a replacement. That makes sense?
Yes.
However, if you are a trustee and there's another trustee, individual or corporation or both, then the retiring trustee does not have to seek a new trustee. Does everybody follow that?
Yes.
Yeah, okay. So that's kind of what is happening in there. A lot of times people don't understand that in its context, and this is why we have to be clear on our understanding of these things, because even in practice, people misunderstand these things, there are oversights, and then things go to court and it gets a little stinky. All right? All right. And notice where the requisite consent cannot be obtained from the beneficiaries or other trustees or whomever, the court has the inherent power to discharge the trustee without a replacement, period. Okay? That's it. Any question on that? Okay, keep going, Cohen.
A court will discharge a trustee provided there is at least one other trustee who will continue to act as trustee or a new trustee is capable of being appointed to the trust. This equitable principle is to ensure that the trust continues to operate in the best interest of the beneficiaries, taking into consideration the nature and extent of the trust.
Indeed. And again, the nature and extent of the trust has to do with what kind of trust is it? Are there any minors in the trustee? If there are minors involved in the beneficiaries, that makes it a little more unique because you can't be fanning around having a big, long discussion while a minor or disabled child or some nonsense like that is sitting around waiting to be serviced. Do you follow? So these things have very real implications. And while I remember, I need somebody to look up the term equitable principle. Anyone? and tell us what that is. I'm just encouraging you to be curious. I know life is hectic, COVID, tired, but I'm just encouraging you to be curious when you get a moment. Equitable principle.
It means bankruptcy, fraudulent transfer, reorganization, insolvency.
Okay. So all of
Correct?
a sudden, anybody else has anything else? Any other meaning?
And equitable principle mean applicable bankruptcy, insolvency, reorganization, moratorium, fraudulent transfer, and all similar laws affecting creditors' rights, generally from time to time in effect, and the general principles of equity, regardless of whether in a proceeding and at equity or at law.
Indeed. And really what all of that is saying in principle is this: whether it's a bankruptcy, a reorganization, or whatever the case might be, the equitable principle is expected to kick in so that everybody gets their fair share. That's what equity is all about. Okay? That everybody gets their fair share based on their commitment to the particular situation at hand, and that nobody is unduly dealt with, improperly dealt with. That's what the equity principle is all about. Equity comes from the word equal, okay? Balanced, something to keep in mind. All right, keep going.
A trust instrument may contain an express power which allows a trustee to retire. Additionally, there are provisions in the Trustee Act 1998 which also permit a trustee to retire. A trustee may retire by obtaining the consent of all beneficiaries who are sui juris and between them absolutely entitled to the whole beneficial interest in the trust. Another way for a trustee to retire is to obtain the consent of the court.
Which we know.
A trustee who seeks to obtain the consent of the court to retire from a trust will be required to pay the cost of the application for such discharge, except in the instance where he has demonstrated to the court that the trust has changed significantly from his initial appointment and/or acceptance to act as trustee of the trust. A retiring trustee of a trust normally requests a release from liability in relation to his trusteeship, which he may be granted on termination of the trust. Where a new trustee is appointed upon the retirement of the trustee, the release from liability may not be granted, depending upon the circumstances.
Thank you very much. So you see down the stretch, we have a situation where the trustee himself, herself, corporation might decide, I've had it with this trust for whatever reason, and they may seek to be retired from the trust. And then as a result, the trustee then goes to the courts, first they can go to the beneficiaries and say, hey, I want out, or we want out. And if the beneficiaries own all the property, they all agree, they can agree for the trustee to get out of the trust. If the beneficiaries decide, dude, you know, you're in this until you die, we're not letting you go, we love you, we this, we that, whatever the reason, and the trustee still wants to get out, the trustee can then petition the courts and say, look, I need to get out, and here's why. Okay? So those are the options. In any event, unless you get settlement or full agreement from all the beneficiaries, or the trustee is extremely clear on how to get out, once it goes to court, as the attorney said earlier, Keith Davidson, that hey, it could get messy before it gets better and you finally discharged. All right. So any question on the retirement of the trustee? I think we're going to beat that horse to death. Okay, and then the removal of the trustee. Who's going to finish that discussion for? Okay, Nishka, since you're right on the Cohen on my schedule, why don't you pick it up? Removal.
Removal. The court may also remove a trustee where he is unfit to act, refuses to act, incapable of acting, The court can remove a trustee without replacing the trustee. See Edwards versus Burroughs, 1844, 9, App Case 371. The removal of a trustee by a court is normally based upon the action of the trustees, which may be due some dishonesty for which he may have been formally convicted, or some financial irresponsibility with regard to property under his trust, or by him becoming a bankrupt.
Yeah, so any of these negative things can then give cause for the beneficiaries to say, we need to remove this trustee. Okay, keep going.
A court may also remove a trustee from a trust where there is found to be continuing friction between the trustees and the beneficiaries. Example, for substantial overcharging by the trustees and the fact that the trustees would have a difficult task of administering the trust in the best interest of the beneficiaries if left to continue to act as trustees. Letters versus Boras. In the case of Beetle versus Chase Manhattan Corporation Limited, 1994, Supreme Court, the Bahamas, number 1.
That's us. Did anybody else get excited when they saw the Bahamas in this thing? Okay.
Yes.
Okay, let's go.
Of 1992 and reported, the court suggested that to remove a trustee, there should be proof shown of some misconduct or mismanagement of the trust assets, and not merely that the beneficiaries are unhappy. In this case, 4 of the beneficiaries sought the removal of the corporate trustee as the company did not sell the 49% interest in the partnership as directed by the settlor, who was given power so to direct in the trust instrument. The discussion centered on the trustee's standard of care, Spite versus Gone, in which the judge stated that it is not indeed every mistake or neglect of duty or inaccuracy of conduct of trustees which will induce the course of equity to adopt such a course. The acts or omission must be such as to endanger the trust property or to show a want of honesty or a want of proper capacity to execute the duties or want of reasonable fidelity.
Now stick a pin, Anishka, because you just spewed out a whole lot of stuff, whether you realize it or not. If we go back up a little to the beginning of the paragraph, we see where the court may remove if there is found to be some continuing friction between the trustees and the beneficiaries. And notice the reasons given for substantial overcharging, to piss off the beneficiaries, you're getting too much money, and that the trustees would have a difficult task of administering the trust and blah, blah, blah. So these are reasons why beneficiaries might bring actions against for the removal of the trustee. Now, it gets interesting down the line in this case, where the beneficiaries saw the removal, Bahamas case, no less, of the corporate trustee, which is one of the private banks who was holding a trust, no doubt on behalf of Tom Jones somewhere, or Mary Sue, because the trustee did not sell the 49% interest in the partnership as what?
Directed by the settlor.
By the settlor. Now, first of all, what is the settlor doing directing a 49% sale? And secondly, because the settlor gave that direction, doesn't mean that the trustee might have agreed that that was the best thing in the best interest of whom?
Beneficiaries.
And what is the primary job of the trustee?
To hold the assets for the benefit of the beneficiaries.
Not only hold them, but to always act
Yes, in their
in
benefit.
what the trustee feels is the best interest of the beneficiaries. So if the settlor said sell, the settlor may have been saying that for his own personal reasons, correct? Because if he's saying sell and giving directions, that means he's having an active role in this trust, which theoretically, what?
He's not supposed to.
He shouldn't have in the first place. And so the question is, why the hell is he directing that sale? For what benefit and for whom? For his or the beneficiaries or all of the above? And why is he doing it? Okay, this is really the trustee's job. And in this case, the trustee did not agree. And so everybody got pissed off with the trustee and wanted to have him removed. Dude, you didn't do what we tell you. The trustee's like, cool, you're just a settler. Don't forget that. I'm the trustee in whom you trust, and for whom I represent the beneficiaries that you have appointed as beneficiaries. I'm doing what I think is best. That's my job. Everybody got pissed off with him, took him to court. Now notice what the courts had to say. Hey, it is indeed not every mistake or neglect of duty or even inaccuracy of conduct of trustees which will induce the courts of equity. What is the court of equity? The court that will always seek to be what? Fair to all parties.
Yeah.
You follow? That's
Yeah.
what an equity court is. To adopt such a curse. And what is the curse? The removal of the trustee just because you have a gripe. That's like a husband and wife having a disagreement or some stupid thing, and then somebody, I leave in you, you dog. And then when you leave and you think about it, you're like, oh man, that was pretty stupid. Now how I go back? And then everything gets egged up because of something silly. Okay? So the courts are saying the same thing. Hey, if you have a disagreement, work it out. Don't blow up the house because make sure it's serious enough. Okay? The acts or omissions must be such as to endanger the trust property. See? Which is really the real important thing. No trust property was in jeopardy here. Or to show a what? A want of honesty, that you haven't proven that the trustee is dishonest, has done anything wrong, doesn't have the capacity, went crazy after COVID or something. No, you haven't shown any of those things. So therefore, or even that there was reasonable infidelity, meaning that they did not act in good faith in doing their jobs. You have not shown any of those important things. All you've shown is he disagreed with my recommendation. And the courts are saying, Mr. Settler and whoever else is behind you, get out of this court. That's not enough reason. If you want the court to change a trustee, come with something substantive. And that's really what that paragraph is about. And actually that paragraph about trustees and settlers and beneficiaries is a paragraph that can be something that we in our day-to-day lives can think about. Because sometimes we make decisions in our day-to-day lives that are based on trivial stuff like, I'm mad, why? Hi, mom, I just vexed. Some stupid stuff. Because you get emotionally tied up in something and you don't think about all the consequences until it's too late. Okay? And so courts are saying, don't come to us until you have something substantive. Other than that, go and work it out. Sleep it off. Stop getting drunk, whatever it is. And stuff of that nature. Okay, and then finally, Anishka.
The court held that it was in the best interest of the court to remove the trustee, as the trust had 6 years before it came to an end, that the asset had been liquidated and dispersed to the beneficiaries.
Now, who understands what that means? What does that mean? In essence, why did the court agree to remove the trustee in this case?
There was no property left in the trust, eh?
No, absolutely. The assets, the property had been what? Liquidated. And the beneficiaries got whatever they were entitled to. So that's a no-brainer, isn't it?
Yeah.
Mhm.
Absolutely. Why would something like that go to court? That's something that their lawyers could have advised.
So
Okay?
even after I disburse the property, the trust isn't like automatically closed if there isn't any more assets.
Depends on the terms and conditions of the trust instrument. If the instrument says upon the liquidation of all assets and the payment to all the relevant beneficiaries according to the requirements of the trust, then the trust is automatically closed, then it's automatically closed. But some trust instruments are not that clear. So you have to petition the courts to close it, or you have to have a formal closing. You follow? Which is a legal document or court order formally shutting down the trust. And that it is not just automatically closed necessarily. Okay? It's just like a mortgage. Anybody has a mortgage yet?
Yes.
Oh, one person has a mortgage. Okay.
Yes, yes.
So two people are finally entering the real world.
I'm adulting now.
You're what?
That's
I'm
the new
adulting
word, I
now.
must say.
Yeah, yes.
Yes.
Three things that indicate clearly that you're entering the real world, and it's not getting a degree from university, BIFS, or anywhere else. Number one, doggone getting married. Mother's sick. Number two, having a baby or two.
What, in that order?
Not necessarily in that order.
Okay.
And number three,
Everyone
getting a
more
mortgage.
details.
If you are doing any of those three, then you are adulting. Yes. Who said adulting?
I did.
Yes, you're adulting. Because those are the three things that will challenge you until the old people say, until you DED. How do you pronounce that?
Ed.
Yeah. Until you're dead. Children, marriage, and mortgage. That's sick. So you guys, you've only just begun. Okay. So this was supposed to be cut and dry. Obviously, they end up in court because somebody egged somewhere, or something. Some formalities had to be done. Some things had to be sorted out before the matter was finally closed. Okay, and then finally, Nishka.
Additionally, the decision in MacPhail versus Dalton reiterated the principle that if trustees are unable to administer a discretionary trust, the court could appoint new trustees to do so. A trustee may also be removed under a power within the trust instrument or by statute. The circumstances surrounding the removal of a trustee under a power within the trust instrument must be clearly related to the power of removal, since the power will often be strictly construed, and the removal of a trustee may impact negatively on the trustee from a moral standpoint.
Absolutely. So again, if there's a provision in the trust instrument for the removal of a trust, that those instructions must be clear, without a doubt, unequivocal, because removing a trustee is like removing a parent from the home. It is traumatic for the beneficiaries as it would be for children. Same principle, okay? And so it is not something to be dealt with trivially, because it has moral and other implications, and in some cases, financial implications. And if minors are involved, God forbid, all kinds of problems, okay? Which is why courts are often reluctant, and they're gonna look at the whole surrounding circumstances. Even if you as a trustee wanna get out and you petition the court, and when the matter gets to court, the courts find out that there are two minors and one disabled, we see your petition. Unless you can come up with anything more substantive, go back and continue as a trustee. See you next year. File another one. We'll review it at that time, because the court realizes, unless of course there's a substitute trustee who's going to take it up and create the same kind of environment of comfort for the sake of the beneficiaries, the courts will not approve it until such replacement trustee is available, agreeable, and in place. Make sense?
Yep.
Absolutely. So this thing about being a trustee is not just about profiting, collecting fees. If you haven't realized that yet, you are completely asleep. Okay? This thing about, that's why trustee fees are so significant, because it's a lot of work being a trustee. Even if you are an individual trustee, a person, and somebody leaves a policy, a property, or some combination for you, when they die, for you to look after their children, you will discover that it is not a simple matter to administer even that small trust. Because first of all, you're gonna have to make investment decisions about the money. Do you leave it in the bank like Royal Bank that only pays you 0.0000 nothing percent? Or do you put it into the credit union who's going to pay you 2 or 3%? or another bank that's paying a similar rate? Or are you going to leave some in Royal for safe custody and some in the credit union in case the credit union closed down, which is not likely that the credit union is going to go anywhere anytime soon. But again, as the individual trustee, now you have to start thinking about these things, because you have to make sure you add to the $100,000 cash and also protect it from bad or poor investments. And then the property, as a trustee, you have to say, okay, this property is increasing in value. I mean, how often am I going to have this appraised? So on. Or should I arrange to get a mortgage to build a duplex on the property so that when the children grow up, they'll have somewhere, the beneficiaries grow up, they'll have somewhere to live. The duplex, one side will pay for itself. Whatever the case might be. I'm just drawing a scenario to show you that even a personal, individual, fairly small Nassau trust that you might be stuck with because you're being nice to a relative or a friend because you promised to do it can suddenly become a pain in the butt. And unless they're very near and dear to you, and doing it free is, does your soul good. You might determine along the way that, wait a minute, I need to be either remunerated for all this work, or I'm going to the courts downtown to petition the Supreme Court to be removed as a trustee. And I hope you don't run into the same thing we just read in that last paragraph where the court say, dude, Susie, I hear you, but these children are going to be minors for another 5 years. Unless you can find me a replacement trustee who's just as good as you or better, you're stuck by order of the court, because this is a serious moral issue. Welcome to a real life situation right here in Nassau, potentially. Okay. By the way, we do have trust companies now in the Bahamas that offer local trusts. So when you acquire some assets, if you don't want to leave a will, you can go to Leno or Bank of the Bahamas or Fidelity or one of these places and actually have a local trust drawn up and say, okay, when I die, 10 cents for everybody every year, or whatever you want that trust to do. Okay, it's very possible. It's not out of your reach, and you don't need to be rich to establish a trust, by the way. Just so I throw that in there. All right. I have a final video that, any questions before we go on with regards to the retirement or the removal of a trustee? Okay. So obviously I've said enough about all that crazy stuff. Just know also that in the real world, just as Davidson was trying to explain, in practice, it's very different from academia. We're looking at the academic side of it, but trust me, there's a whole lot more involved. As a matter of fact, I'm looking at 2 trust texts in my study with all about trust activity on the one hand, and then a whole other text about trust accounting and the management of finances and funds and investments with trust. So this trust thing, what you guys are doing is like the beginning, and hopefully you'll go on and do more advanced courses in this area if you're interested. But it's just to let you know that this trust thing is a very wide and encompassing and exciting. Okay, there you go. Thing. All right. So have a look at this video. Actually, this talks a little about appointment, retirement, and removal. So it's kind of a summary of what we were talking about in the last 2 sessions. And so that's one of the reasons why I selected it, so you can see what other people are saying about it as well. There we go. Okay, where is it? There we go. Can you see it?
Yes.
Fantastic. All right.
That's the old video? Or that's the new video? It's the end of a video.
That's the old one.
It's the end of a video. Okay.
Who recognized that?
Me.
Hold on it, Anishka. Where do you work again, Anishka?
I work for Central Bank.
Oh, no wonder. Dog,
Regulate you.
yes, they don't do nothing. Thank you very much, Aniska. That is the old one. The end of it.
I just assumed it was a same person doing a next video.
That is a good assumption. Sometimes that happens. Okay. Where's the one that I want? Okay, that's the one. Can you guys see that?
Yes.
Okay, great. That's the one I want. Equity in trust, appointment, retirement, and removal of trustees. Okay, kind of a little summary. And I like that they throw in the word equity in relation to trust because as you now know, equity is a very important part of the process. Okay, period. So Anishka, you work at the central bank?
Yes.
What section again?
Exchange control.
How long have you been in exchange control?
I've only worked at Central Bank for a year now.
Oh, you're a babe in swaddling clothes.
I was at First Caribbean for 9 years.
Who the hell is First Caribbean? I'm
Who,
just
what?
being the devil's advocate. You don't have to answer that question.
The rest of us on the call.
The rest of them worked at First Caribbean.
Oh, really? Then I can appreciate your reluctance to respond. But just let them know that you're now a central banker, and before they know it, you will be in bank supervision somewhere, going out to inspect trust companies. And see,
I received that in the name of Jesus. I received that.
Maybe some of them in First Caribbean as well on the domestic side. So you guys are all getting information that will be helpful to you one way or the other, especially Anishka, who might one day be a bank inspector coming out to inspect doggone domestic and international banks who have hundreds and hundreds and hundreds of trusts system, the old people used to say. All right? So learning is never a waste of time. That's my point. If I don't know if there's a part 2 to this, if there's a part 2, do it. Because life is full of ironies. That's all I can say. Been there, done that. Okay, let's go.
In this module, we will look at the appointment, retirement, and removal of trustees. There are a number of restrictions upon a person's ability to act as a trustee. A minor may not act as a trustee by virtue of the Law of Property Act 1925. However, the appointment of a minor trustee does not render the entire trust void, as the power to appoint a replacement trustee is expressly unaffected by the Act. Under the Trustee Act, where a trustee remains outside of the UK for more than 12 months, they can be replaced. It is not possible to appoint a mentally incapable person as a trustee. Any person who, after their appointment, loses mental capacity can be removed by virtue of the Trustee Act. Where a trustee who has lost mental capacity had made an enduring power of attorney, which was registered before the 1st of March 2001, their attorney will have the ability to discharge their functions as trustee. Under the Trustee Act, there may not be more than 4 trustees of a settlement of land. However, there is no restriction on the maximum number of trustees of a trust where there is no settlement or trust of land.
In case you haven't noticed, under UK, seems to be very similar to ours. They didn't get it from us. We got it from them.
Yeah,
Okay? Let me just make that clear in case that's still not clear. Our Trustee Act is just a modern version of their modern version, so to speak. Okay? Like we've done in many other cases like national insurance and so many of our other laws that we have currently tweaked to some extent. Some of them are still old and antiquated to suit our environment here in the Commonwealth.
E.g., a trust of personalty, such as chattels or shares in a company. Under the Law of Property Act, a minimum of 2 individual trustees or a sole trust corporation is required to give a valid receipt for the proceeds of sale of land. Under the Charities Act and the Pensions Act, bankrupts, those who have entered into an individual voluntary arrangement with their creditors, Those convicted of an offence of dishonesty or deception and those disqualified from acting as company directors are precluded from acting as trustees of a charitable trust or of a pension scheme trust.
That makes sense?
Yeah, I might use some money.
Yeah, of course. If somebody comes to you for
I don't have any bankrupt.
sorry? Yeah, if
Person
somebody
is
comes to you
bankrupt.
for a job and they say that, have you ever been to prison? And they said yes 3 times. Why? I mean, I'm not saying that they may not have been rehabilitated, but most companies would be reluctant.
Yes, risk
Right.
too high.
The same thing with bankrupt. If you're a bankrupt, then folks are going to say you're not a responsible person, which is typically true. Not always. That's why if somebody said I'm bankrupt, you can't say, get the hell out. You should explore it because the bankruptcy may not have been their fault, what? Directly. Even the person who came out of prison, you can't say you've been to prison, get the hell out. We don't want no prisoners here. If you, except that's what we tend to do. But
Yeah.
notice what can happen if all you have to do is take 1 or 2 steps more and say, look, why did you go to prison? And now look at what they say. I was wrongfully accused by a witness. See? Now they went to prison, but if they were wrongfully accused and you go to the court documents or you get a document from the court saying that is correct, then your perspective is supposed to change, shouldn't it? No?
Sure, it should.
I hope so. Unfortunately, some people, even after they get the real facts, once you say you've been to prison,
Yeah.
they don't want to deal with it, even though it's not the prisoner's fault. That's an unfortunate truth. That's why some people, when they come, they lie and say no, because they know that once you say yes, no matter what you say after that, it's like being a prostitute. I used to be a prostitute, but I'm born again. Doesn't matter. People get stuck on prostitute. But you say, but I'm born again. They're like, maybe. Just human nature is like,
We'll wait and see.
yeah, we always want to get stuck on the what? Negative, rather than explore the whole picture. All right. Okay, so that's the introduction. Next week, I'll let you guys have a look at a little discussion
Hi, Clint Coons
on
here
the-
with Anderson's Business.
on the removal and retirement of trustees. I just wanted to do that little introductory note. Any questions on anything we've discussed tonight? No? Okay. Then if that is the case, I'm not going to drag you guys deeper in the mud tonight. You've been great these last 3 sessions. So I'm going to let you off a few minutes earlier today to go ahead and get ready for next week's topic, which is?
Next week.
Time.
Next week.
Sorry. That is the role
The
and
role and responsibilities of the trust administrator.
Absolutely. That is our discussion for next week, our final session. Also, please go ahead and do the self-assessment for tonight and next week's session.
Okay.
What have you? I already finished tonight's self-assessment.
Then you are ahead of the game.
Go to the
Okay? That means you only have 1 to do instead of 2. Your colleagues will have to go and sweat it out and do the other 2. And-
That's fairly easy. So they got it. They can finish that in a couple minutes.
Oh, it's
Yeah.
not bad. Wonderful. That's what I was hoping to hear because it is not that bad. Okay, so go ahead and do those 2. Read up for next week, and I'll see you guys in 2 kicks and a shake when we finish up, so you can move on to the next level.
Okay.
Okay.
Have a great week and be safe out there.
The Prime
Yes.
Minister is talking on Nemo. Okay. All I caught was some places closing 12 o'clock tomorrow. So y'all go listen to him. Okay.
My God,
All right.
yeah, that is very serious.
I know First Caribbean closing 1:30 tomorrow. So y'all straight.
Oh,
Yeah.
Oh, really? You got that news?
I
Anyway,
got it.
that's breaking news to me.
actually good news coming out of First Caribbean.
Breaking news for me.
But y'all be safe this weekend, please.
Absolutely.
Yes, likewise.
I'll be looking
Bye.
to see all of you guys next week.
Okay.
Bye.
Take care.
Good night.
Good night.
following the passage